I'm Kat Grazios. I'm an associate here at Schoeneck King. I am a part of our higher education and healthcare practice groups. And I'm here with Seth Gilbertson. We're going to speak today about study abroad accommodations under the law. Next slide, please. So a bit of a roadmap of what we're going to go over today. First, we're going to start off by discussing some of the statutes that are on point that apply to the study abroad accommodations. Next, we're going to go over some case law. Not that there's too much on it, but we're going to review what is on point for study abroad accommodations. After that, we'll go through some regulatory law and the OCR decisions that apply here. And then Seth will speak to policy considerations and the practical application of this presentation to your programs and institutions. Next slide, please. So you may be wondering, how do disability accommodations apply to my study abroad program? Well, there's two different statutes that institutions of higher education should be aware of when considering accommodations for students. Section 504 of the Rehabilitation Act of 1973 and Titles II and Titles III of the ADA prohibit colleges and universities from discriminating on the basis of disability against otherwise qualified individuals with disabilities. I'd also like to note that for purposes of our presentation today, we're not going to be distinguishing between sections 504 of the Rehabilitation Act and the ADA's Titles 2 and 3. We're going to speak to them in their totality and how the three of them apply together to institutions of higher education. Some language that we pulled from sections 504 in the ADA. No individual shall be discriminated against on the basis of disability in the full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations of any place of public accommodation by any person who owns, leases, or leases to, or operates a place of public accommodation. You may be familiar with that language and you may be wondering, well, how do 504 and the ADA apply to my institution? Like, why do they apply to my institution? Well, the reason for that is Section 504 prohibits a discrimination against individuals with disabilities in connection with programs and activities that receive federal financial assistance. So this is nearly every institution. Almost all institutions of higher education receive some sort of federal funding or assistance. So again, this applies to all colleges and universities. Then Title II of the ADA applies to state and local government operated higher education institutions, while Title III of the ADA applies to various categories of private providers of public accommodations. This includes private colleges and universities. So you're setting up a mental framework for Title II applies to our state and public universities. Title III applies to our private universities. Next slide, please. Some more language that we thought was useful to pull from 504 in the ADA, a failure to make reasonable modifications in policies, practices, or procedures when such modifications are necessary to afford such goods, services, facilities, privileges, advantages, or accommodations to individuals with disabilities. And then we want to note here, we italicize this language, unless the entity can demonstrate that making such modifications would fundamentally alter the nature of such goods, services, facilities, privileges, advantages, or accommodations. And so there's a limit to the accommodations that must be given, in that the entity can demonstrate that making the accommodations would fundamentally alter their study abroad program. Next slide, please.
I'll just pipe in there.
Yeah, please.
Some people, I know there's a lot of lawyers and disability law experts on the program today. And you may be saying, well, what about undue hardship? And this comes up a lot in the context of study abroad. It comes up a lot generally, but I can tell you that from conversations with OCR and from some of the case law we're going to talk about even, the undue hardship argument is not going to be successful here in almost any case. Specifically, there is no court, and certainly not OCR, that is going to look at the narrow scope of a program. So you can say, I only have 15 students on this program. We can't afford to spend, $10,000 on a sign language interpreter for this program because we're only charging the students, a couple of $1,000s a piece, and it doesn't add up. They're not gonna look at the program. You can say, we only send 200 students abroad every year. We can't, we don't bring in enough money as an office, the Office for Education Abroad, or whatever you may call it on your individual campus. They're not gonna look at that office. They're gonna look at your entire institution. They're gonna say, oh, well, gee, I see here, you publish an endowment of several $1 million, maybe $100 million, maybe more, and why can't you afford $10,000 for the sign language interpreter or whatever the case may be? So I just like to kind of nip the hardship argument in the bud a lot of the time, because it is rarely going to be a successful option for trying to challenge or evade ADA requirements. So that's why we focus on the fundamental alteration part, which I think does have some usefulness and applicability and is something we want to be considering very seriously in this context.
Thanks, Seth. So I'll continue on with some language that I'm sure you're familiar with from the ADA and 504. Section 504 in the ADA protect only individuals who, one, qualify as an individual with a disability under the applicable statutory definitions, and two, are otherwise qualified for the programs in question. So the ADA defines an individual with a disability as one who has a physical or mental impairment that substantially limits one or more major life activities, or a record of such impairment, or is regarded as having such an impairment. And interestingly enough, Section 504 uses the same definition. Institutions of higher education must also consider whether the individual is otherwise qualified, i.e., are they able to carry out the essential requirements of the program with or without reasonable accommodation. Next slide, please. So I'm going to speak a little bit to extraterritoriality, because you may be wondering, well, we're dealing with federal statutes here in the ADA and in Section 504, but we're dealing with students who are leaving the American jurisdiction and going to different territories that have their own sets of laws and rules. So how do our American laws apply there? The theory that this would apply under would be known as extraterritoriality. Congress has the power to extend the application of its laws extraterritorially or abroad. However, historically, there's been a presumption against this extraterritoriality in determining the reach of federal legislation. In 1991, the Supreme Court affirmed this presumption in the case of EEOC v. Arabian American Oil Co., or Aramco, holding that Title VII of the Civil Rights Act of 1964, which prohibits employment discrimination, did not apply extraterritorially. In response, Congress enacted the 1991 Civil Rights Amendments, which effectively overturned this EEOC versus Aramco decision and extended Title VII of the Civil Rights Act and Title I of the ADA to overseas conduct. However, with respect to disability discrimination, Congress extended the reach only of Title I of the ADA, not of Titles II and III, which Title I concerns employment discrimination, and as we mentioned before, Titles II and III of the ADA apply to public accommodations and institutions of higher education, as we see here. Although Congress's failure to extend the reach of Sections 504 and Titles II of the ADA in connection with the 1991 amendments may have created or reinforced a presumption against the extraterritorial application of those laws, it's possible that courts and administrative agencies will choose not to recognize or enforce such a presumption, as we're going to see in the next few slides when we discuss some of the federal case law and some of the OCR decisions. Additionally, there's a number of practical factors that weigh in favor of colleges and universities operating under the assumption that Sections 504 and the ADA apply to their study abroad programs. Seth will speak to this more, but you may want to consider public image and how it would look for your university or institution to not offer these accommodations. Next slide, please. So a few federal courts have examined the applicability of federal disability discrimination laws to study abroad programs, but there's at least 2 court opinions that signal that courts may find extraterritorial application. The first case we'll discuss is Byrd v. Lewis and Clark College. I should note that aside from the federal court cases, the Department of Education's Office of Civil Rights, which enforces Sections 504 and the ADA as they relate to disability accommodations for college and university students, has issued various opinion letters involving disability discrimination in study abroad programs. 3 of these opinion letters declined to address the extraterritoriality question directly, but seemed to employ an analysis that assumed extraterritorial application. And one opinion letter concluded that federal disability discrimination laws do not have extraterritorial application. Again, I'll go through these in the next few slides. Turning back to the Byrd decision, in Byrd, a federal district court in Oregon held that Section 504 in the ADA did apply to study abroad programs. The plaintiff was an undergraduate student who used a wheelchair to participate in the college's study abroad program in Australia. The college accommodated her disability in many, but not all activities, and at times she had to be carried. The student sued the college in federal court on a number of theories, including sections 504 and ADA claims, and breach of contract and breach of fiduciary duty claims. In ruling on the extraterritoriality issue, district court emphasized that the plaintiff was an American student participating in an American university's overseas program taught by an American faculty. Based on these facts, the court found that the presumption against extraterritoriality should not apply and cautioned that sections 504 and the ADA did not apply to study abroad programs. Students, in quotes, the court noted in a special hearing on the extraterritoriality issue, they said students in overseas programs would become the proverbial floating sanctuaries from authority, not unlike stateless vessels on the high sea. Next slide, please. So that decision was in a district court, which was appealed up to the Ninth Circuit. On appeal, the Ninth Circuit declined to address the district court's ruling on extraterritoriality, but nonetheless denied the plaintiff sections 504 and ADA claims, finding that the school's program, when viewed in its entirety, was readily accessible to and usable by individuals with disabilities. Interestingly, the student did have some success in this claim in that the court did conclude that the college had a fiduciary relationship with the student under the state law because the college assured the student that it would accommodate her disability, assured the student's parents that they commonly assisted students who were more physically challenged than the student, and indicated that adequate facilities would be available for most of the outdoor trips. The court found that the student had a reason to trust the college's assurances because the college had accommodated the student on the home campus. So essentially, the court found a breach of fiduciary duty claim, and the student had some success on that narrow issue. Next slide, please.
I'll just mention on the Bird case, I think one of the important sort of background facts to know is that the student actually was in a car accident during her attendance at Lewis and Clark. So the things that the campus actually went to great lengths to accommodate the student who had acquired the disability during the course of her studies and changed things like laboratory arrangements and made physical modifications to campus. Really did a lot, went above and beyond what it probably had to do, at least at that time in the early 90s. To accommodate this student, and built a level of trust. And you can kind of read it between the lines in the court case that they, it's not that they were used against the institution, the fact that they had done all these things to accommodate their student, but had built up a level of trust and then betrayed it in some way by making promises, making assurances. One of the individuals that she named was the person that she had been working with, and the dean that had been trying to help her. She did end up graduating from the institution, but they built up such a level of trust, and then when on this program that they had assured her would be accommodated, she would be accommodated. What she experienced was something very different than what other students experienced, and I guess the other thing that I would mention here is the differences were not discussed in advance with the student, and they were of a nature that there's no other way to say it other than humiliated the student. The student was in a wheelchair. The institution had worked with its foreign partner in Australia. The group was traveling in the outback. They had said, we're going to make these things work. A lot of times the way to make it work was to hire a couple of blokes to pick up the wheelchair and physically carry the student from place to place. Not exactly a comfortable way to travel, not a good way to see pictorials in a cave or look out over the Great Barrier Reef and things like that, which are some of the things they literally were doing. In some cases, the student even had to be carried into bathrooms, showers, things like that. So, you can just imagine that's not what the student signed up for, not what she experienced, not what she thought she was being promised by the institution. And just, I think there's another lesson in there too, is the institution really relied on its foreign partner, an entity that it had been working with for a long time, who clearly did not really understand what it meant to accommodate this student, and I think made assurances back to the campus. The campus took those passed them on to the student. The student took those, and ultimately a lot of bad communication here that I think kind of led to this outcome and led to this dispute.
Thanks, Seth. So our next case that I'll touch on is Texas v. University of San Francisco. In this case, a law student with attention deficit hyperactivity disorder alleged that the University of San Francisco did not accommodate his disability during his participation in its study abroad programs in Dublin and Prague. Specifically, the plaintiff claimed that professors made it known to other students that the plaintiff was receiving special testing accommodations and that a maintenance person disrupted the plaintiff during a testing session. Citing Byrd, the Federal District Court for the Northern District of California rejected the student's claim because the program, when viewed in its entirety, was readily accessible to the student, and the disruptions to his accommodations were limited exceptions to the rule. The court did not address the extraterritorial application of sections 504 in the ADA, but by citing to Byrd, it seems that the court, at least to some extent, agreed that the ADA and sections 504 may, at least in some circumstances, apply to study abroad programs. Next slide, please. So moving on to some of the administrative decisions that we've seen. At least one OCR regional office has clearly stated its position that the ADA and sections 504 do not apply to study abroad programs. In Arizona State University, this is an OCR Region 8, November 29, 2001 decision. A deaf student requested that ASU provide a sign language interpreter for him while he studied abroad at an Irish university. ASU denied this request, and the student filed a complaint with the OCR. OCR concluded that sections 504 and Title II protections do not extend extraterritorially, nor does either statute otherwise prohibit discrimination on the basis of disability in overseas programs. Important to note that some commentators have stated that, unlike the Byrd case, the ASU student sought to attend a program run not by a U.S. institution but rather was run by a foreign university. Next slide, please. So in three other OCR regional offices, seemingly the OCR concluded, without explicitly discussing extraterritoriality, that under certain factual scenarios, sections 504 and the ADA do not apply to study abroad programs. In Hassan College, OCR Eastern Division, January 5th, 2005, a student applied for a nursing program class offered in Honduras, but claimed that she had disabilities that caused constant headaches in periods where she was unable to function mentally or physically. The college discussed with the student the medical and safety issues that could arise if she participated in the class, and subsequently the student withdrew her request to participate. The student then filed a complaint with OCR, alleging that the college denied her the opportunity to participate in the Honduras program. OCR may have been able to dismiss the complaint based on a lack of extraterritorial application, but it didn't. OCR simply found that the college never denied the student participation and that it was reasonable for the college to engage in discussions with her about potential safety issues. Next slide, please. In College of St. Scholastica, a deaf student alleged that St. Scholastica discriminated against her by denying her request for sign language interpreter services during a study abroad program in Ireland. The OCR found that the college did not properly address the student's accommodations concerns, did not examine the cost of interpreter services, and had no formal disability-related grievance procedure. Thus, OCR determined that the college had violated Section 504 by refusing to provide interpreter services. So while it appears that neither St. Scholastica nor OCR explicitly addressed the potential presumption against extraterritorial application of Section 504, OCR's decision makes clear that, at least in the opinion of that regional office and under the factual scenario presented, Section 504 indeed did apply abroad. Next slide, please. So our final OCR decision that I'd like to cover is that of St. Louis University, issued by OCR Region 7 on December 12, 1990. In this case, in this instance, a student with a learning disability alleged that St. Louis University violated Section 504 by providing him with an IBM computer instead of a Macintosh computer on its study abroad program in Spain. OCR concluded that there was no evidence that the student should have been provided with a Macintosh over any other computer and that the university had not violated Section 504. Again, while this decision did not explicitly address the extraterritoriality question, OCR's analysis of Section 504 suggests the belief that it applies abroad. So as we're seeing, there's a split here in whether extraterritoriality would apply ADA and Section 504 to the study abroad programs. And with that, I'd like to turn it over to Seth.
Thanks, Kat. Excellent. I will just note, and if we could get, I know we can't have a proper applause, but by my count, Kat said extraterritoriality 12 times and only slightly tripped up on it once. I can tell you my hit rate would be way, way above that if I tried 12 times. So I'm going to do it one more time and then you won't hear me say it again. Let's see if I can do it. So extraterritoriality is interesting. Next slide, please. But sometimes it doesn't matter all that much. We saw that to some extent in the Bird case, where you had promises and assurances that were made by the institution that basically trumped ADA. And it ended up being a fiduciary duty case. Really, it could have been a contract, an applied contract case as well, where you had promises that were made to the student, and then the institution didn't live up. ADA is an obligation. Section 504 is an obligation, a legal obligation that is imposed from outside. But as many of us know, certainly all the lawyers online know, you can also impose obligations on yourself internally. And many, if not all of you, have done that. These are a couple of statements. I don't know if they're from institutions on the call. I won't call it where I got them, but I can tell you I've visited many of your websites before. I may have helped some of you draft language that you're using. But you all make some kind of assurances about providing individuals with disabilities equal access and opportunity to your programs and services. So equal access and opportunity to programs and services. There is really no argument, I don't think, that study abroad programs are part of those programs and services offered by your institution. If you're making these promises, you're going to have to live up to them. And you are. And I'm not criticizing the fact that we make these promises. These are values that are baked into what we do and to our very mission as institutions of higher education. Certainly, we want to accommodate students where we can. We want to provide equal access to all of our programs and services. But just be mindful of this language whenever you think about sort of falling back on a technical extraterritoriality question. There, I did it one more time. That's the last time, I promise. So think about your language, look at your language, and ultimately know that you not only should live up to your own language, but you will be held to that standard someday, should it come to that. Next slide, please. So that's language most of you already have. Some of you don't have language like this, and I again, I won't call out the institution, but I came across this language a while back, and I kind of held on to it because I really liked it. And this is right on the sort of front page of the website. It's in the initial information a student would encounter when they're visiting their study abroad site at their institution to determine, look at programs, look at program information to see if this is something they'd want to do. Look into it. They're going to come across a statement like this. And the earlier you can get to a student and start discussing this issue, the more successful you're going to be in planning interactively with that student for a successful study abroad program. So you want to get this language in front of them. It also seriously indicates to me that this office at least has if they don't have an accessibility specialist right in study abroad, right in the Office of Global Education or whatever they call it, they clearly have a link. They have an association. They have a connection with the Office for Disability Services, Student Access, whatever they call their office, where they have, they've had these conversations before. How are we going to handle these situations? And that is a key part of your success here. You want to get expertise on both sides of the equation, both on the study abroad side and on the student accessibility services side. Together, working together, talking to each other, working through these problems, working through these issues to try to figure out the best case scenario, the best strategy for accommodating students, for both getting students into the right programs where they're going to be the highest potential for success, the highest likelihood for success, and then providing individual accommodations to those students to enable them to be successful in those programs. Next slide, please. So that's one of the first things I'm going to start with in sort of the pointers here. Make sure you are partnering with your disability services office early and often. They have expertise, and if I'm speaking to a study abroad person right now, I'm saying they have expertise you don't have. They live and breathe this stuff. They know how to deal with they know how to get the documentation. They know how to open the discussion with the student. They know how to work interactively with the student, with providers. They probably don't know anything about running a trip in Morocco. Okay, you know that part of it. The study abroad folks know that part of it. And so you need to translate that part to them, and they need to translate their part to you, and you need to work together and bring both your expertise to bear, particularly on some of these more complicated problems that you're going to run into, because you are going to run into difficult problems sometimes that you need to solve together with hopefully with the student involved as well, which is so obviously the nature of the interactive process that we want to engage in and provide. And a lot of that is translating back to the student as well. Here's what you've done. Here's what we've done in your residence hall. Here's what we've done in your classrooms. Here's what we've done in your laboratories. We're going to try to translate these, successful accommodations that we've put in place. We're going to try to sort of bring those with you, but it's going to be different. It's going to look a little different. It's going to take some different strategies. The hotel or the homestay that you're staying at in this foreign jurisdiction is very different than the residence hall at home on your campus. So we need to figure out how to make the strategies that we've used there work someplace else in a different environment, and you really need to have those people together. So provide clear information to students about where about how to seek information about these accommodations early. And again, I think it's really, really best if you can get to a student before they've settled in on a program, when they're just starting to think about going abroad for a semester. So whether that be when many institutions have an orientation session of some time where maybe the study abroad person gets up there and talks for 5 minutes about what kind of programs they have, when they can, how they should consider them, when they should go during their academic career, whether it's best to go sophomore or junior year, those kinds of things. Talk about it then. Talk about it early, and say let's talk about this now as we're doing an initial consultation about where you'd like to study abroad. If you're meeting with a study abroad advisor, and you may have several options, they may come in with an idea. They want to go here, but then you get talking to them a little bit. You talk about some of these issues, and you determine it may be better to go someplace else. And a lot of that, there's going to be a lot of factors that apply to that, that are very individual to the student's needs. But one of them also is going to be, frankly, who your partners are, who you're working with. And if it's a faculty-led program in particular, the size of the program is going to matter, and the experience of the faculty member is going to matter. And you want it to be, we all know, working in study abroad, when you're dealing with individual faculty or leading programs, some are better at this than others are. Some are really, really good at lecturing about archaeology, but really, really bad at managing 20 students on a program. So you want maybe not really, really bad, but not as good as the art history professor who's going to Amsterdam, right? So we want to think about those things in advance. If a program does have physical requirements, this would be another one where the bird case, I think, can be instructive. If a program has specific physical requirements, put those in, like technical standards. For those of you who are in disability services or legal offices, you're familiar with technical standards. Apply those in this context as well. There's no reason why you can't. publish those early. So when a student, again, when a student is looking at your literature, at your website, and they're looking at, different programs, they're going to see those early and realize, oh, maybe this isn't the best one for me because it says you got to be able to climb, X number of stairs every day, or you have to be able to go on a boat or something, whatever it may be. And then you don't actually want to be, so you want to be providing, at some point you want to be, early on, you want to be providing information outward to the student. At some point, you're going to need to get information back from the student. That should occur after program admission. So you don't want to be asking those questions. Those are the questions you don't want to be asking early. You want the student asking you questions, you providing information. After the student is admitted to the program, that's when you have to actually start asking about individual needs, health needs related to that student. I think generally the study abroad office is not the best place to gather and retain that information, whether it be a student health center or the Office for Disability Services on your campus is probably a much better place to ask for and gather that information. Then they're going to work with study abroad to implement the accommodations. Frankly, they know how to handle the privacy issues related to gathering that information. They know how to interact with providers. They know what information to ask for, not too much information, just enough information, etc. So I would work with them, and make sure that you're bringing that information in the right place. Because if you have an untrained individual asking these questions, they're going to ask the wrong question. They're going to ask it at the wrong time. Next question, or next slide. All right, so engage the student in the interactive process, again, with your disability services office, and maybe that is you, and for some of our audience, but if that's you, then you're working with your study abroad side of the house. Be very honest with students about the difficulties they're going to face. Now is not the time to be super delicate, beat around the bush. You want to get right to the point and explain in particular detail what kinds of things the student is going to face. Remember, particularly in the study abroad offices, we have people who are world travelers. They got into that business for a reason. They know a lot about it. They know a lot, and it's sort of intuitive to them, the difficulties that go along with that, particularly traveling to a someplace with different language than you may be used to, or geographic differences that may be difficult to get through, or a place that is less developed in terms of infrastructure. And the difficulties that may bring along with it. So you want to make sure you're communicating that to the student. You know that stuff. This is probably the student's first time traveling abroad. For the overwhelming number of students, they may have been to Toronto, but we're talking about that's a long way from Morocco, right? So just to go back to that example, so they don't know what this is going to be like. Make sure you explain it to them very clearly so that you can have an effective interactive process. And again, there's nothing wrong with counseling a student towards a program they're going to be more likely successful. That is different than denial. Denial is something you're only going to do in a very extreme case where the necessary accommodations in order to make the trip successful would constitute a fundamental alteration. And I emphasize that term, fundamental, because you're going to have to do it, particularly when you're talking to faculty and study abroad in faculty-led programs, what that means. That doesn't mean that because you have to change up your site, or because you have to change up your transportation, or because you have to change up the hotel that you usually like to stay in, and you need to stay in a different one. That's not a fundamental alteration. That's a minor alteration. That's an alteration, a reasonable accommodation that you're going to have to engage in. They're going to have to sort of, you're going to have to be the gatekeeper on that fundamental question. That's a tall ask. There are a lot of reasonable accommodations that do not constitute a fundamental alteration of the program, and we're going to have to be flexible with regard to making some changes to the program to make sure that a student can be successful. And then finally, if the student would if the student's participation would constitute a direct threat, again, very high standard. Next slide, please. All right, so train the office, and I say your office, I'm really talking to study abroad folks here. I don't know how many of them are on, but that's sort of the target audience of a lot of this stuff, because they're the ones that are doing much of the work on the ground. So train the office how to deal with these issues. A lot of these things that we're talking about are things that should be discussed with a program advisor, with individual trip leaders. These are things you should be covering in your orientation that goes into approving faculty for leading trips abroad, or for, frankly, working with your partners who are providing, whether it be transportation, trip related things, or even the academic experience if it is a partner who is a foreign educational institution. So train them. Also, sometimes you're not going to get students who come to you early and talk to you about these things, and you're going to have to wait and hope it doesn't happen, but it's going to happen. It happens a lot where these issues arise after the trip is already left and you're underway. And the student thought they were going to be fine, but you know what? The change in schedule, the jet lag, it really impacted them and exacerbated an existing underlying health issue. And now you're dealing with it. Train trip leaders to spot those things early and get back to campus, not physically get back to campus, but communicate back to campus about them so that you can try to provide accommodations in real time. We do that in the academic setting. We got to do it here too. You have a student who's struggling to hear a class, and they come in and talk, and you put them in front, right? Halfway through the semester, or they're struggling to keep up the material. Maybe you help with tutoring, or maybe you help with extra time on tests and quizzes, something like that. So these are things that we need to be prepared. We need to keep our knees bent and be ready to adjust on the fly. Confidentiality. One of the things I was going to mention earlier is that there was the one case that talked about privacy, and it was in Ireland. Interestingly enough, that was in mid 90s, I think, well before GDPR. Right now we have GDPR. We have the new Indian privacy regulations. We have the new Chinese. Well, they're not that new, but the Chinese privacy statutes that went into effect a couple of years ago, and really are coming to bear now as we reopen programs internationally. These things are going to have major effects on our ability to do what I just told you to do, and that's work with have your trip leaders abroad, work with your experts back home. All right, so we want to make sure we're getting consent where we need to. We want to make sure that we're communicating only the information that we can communicate when we can communicate it with the student's consent. In many of these cases, and that's another thing you can bring up to students in advance. Let's talk about these things now, because we may not be able to share information as we want to share, particularly health information, by sending it in or out of the country that you're in while you're actually participating in the trip. So we want to get that done now. Finally, consider how technology can boost it. This is particularly important, I think, with regard to mental health issues, where you can provide counseling, via Zoom. Nowadays, that's not even a big deal. If I gave this presentation 3 years ago, people would go, "Oh, I don't know, telehealth, that's very different. It takes a lot of getting used to." Students are used to working, sitting on the couch across from their counselor when they're talking to their mental health counselor. Nowadays, students, for the most part, are used to it. They've all lived with it. If you're receiving mental health counseling or something like that, you've probably been doing it online the last couple of years. So, keeping that up is really important for a semester away or for a study abroad program, even a few weeks. They may think, "Oh, it's fine. I'll talk to my counselor before I go. I'll talk when I get back." But students don't always understand how all the things, the food, the smells, the lack of sleep, everything can impact mental health and exacerbate existing underlying health issues when you're traveling abroad. So these are things you want to consider and figure out how to use technology to help that. That can also help with the communications factor that I just spoke about, where you can actually have students talking to people, sharing their own information, which oftentimes doesn't raise the same privacy issues that it might if they talk to their trip leader then relays the information back to the home campus. So if you can have the student relaying that information, working with their provider or your student accessibility office or somebody like that directly, oftentimes it's not going to implicate the same privacy restrictions. And then finally, I just wanted to mention animals. It came up here the other day talking to somebody. So for the most part, ESAs or assistance animals are not going to be something that we would provide in a study abroad context. Service animals are one that you're going to have to look at much more closely. That's the big difference is for us is that ESAs or assistance animals are generally required to be provided under the Fair Housing Act. The Fair Housing Act does not have extraterritorial application. I think I can say that pretty safely. Whereas the ADA may, service animals to some extent may be required. Now, you are going to encounter roadblocks in that situation where you're going to be encountering difficulties, particularly with regard to local laws in the jurisdiction that you're traveling to, that are going to make it impossible. You will have plenty of jurisdictions that say no pets in residence halls, and they don't make a distinction between a service animal and a pet. They just say no animals. And if you can't find a place to stay, you can't, or in transportation, that's going to be another issue where it comes up where you're using public transportation, or you're using a chartered provider, and under their license, they're not allowed to transport animals. You're going to get into those situations. That's another place where you may want to have some of those conversations about the right location with the student. So just some things to consider there. Generally, service animals are going to have to at least work with. What I usually say is work through the process until you hit that roadblock. I'm not saying you're not going to hit it, but make sure you're working through the process and you're not immediately saying no to the student when they come in with it. All right, next slide, please. I think I've hit on all of these points already, at least most of them. So just sort of a reiteration of many of these, but the final point, I guess I haven't really talked about that much, and I don't see any questions in the Q&A, so I'll go ahead and hit on it now. If you do have questions, throw them in there now, or you can obviously contact Kat or I after this program anytime. But I will just mention building in the cost of providing accommodations in advance is key here. These things are going to cost money sometimes, particularly with regard to short-term study away programs, faculty-led programs, things like that. You can't put the burden of providing the financial burden of providing accommodations on that individual trip. It has to be on the institution. The best way to do it, in my opinion, is to have basically a small tax on every student who travels abroad, on every study abroad program. It's built into the program fee. It goes into a separate account, and then you have an account that you can use to draw from when you have a particular accommodation that needs to be provided. It's going to cost a lot of money. You can't put that on the backs of all the students who are just going on that program. You can't even put it on the backs sometimes of all the students who are traveling abroad, that semester, that year. You want to build it in for long-term success. Have a pot of money to draw from when you need it, and that it's sitting there. If you never end up using it, great. I'm sure you can find somewhere else to spend it if that pot gets too big. But my prediction is that's not going to happen, particularly with the accelerated pace of both students with disabilities and seeking accommodations on campus, and hopefully the accelerated pace of students wanting to go abroad, which I've heard anecdotally from a lot of people. Students want to go, that we want to get back to business here, sort of post-pandemic, and hopefully a lot of students are going to be going on these programs, but just acknowledge that a lot of them are going to come with needs that you're going to have to accommodate. You're going to have to be ready to accommodate. And I still don't see any questions, so I think that's it. Please reach out if you do have questions to come up afterwards. I want to thank Kat and Kathy, and thank you all for coming.